What if one missing document could now cost you your US immigration case? That is the concern facing thousands of immigrants after the US Citizenship and Immigration Services, or USCIS, tightened its application policy. From August 5th, USCIS officers can deny certain immigration benefit of the applications without first giving the applicants a request of evidence, or RFE, and the required financial initial documents when filing. And that is a major change. Under the earlier approach, applicants often had an opportunity to correct the missing evidence and after receiving the RFE. Now, that second chance is no longer guaranteed. But it gets serious for the Indians. The US has a large Indian population on H-1B and F-1 visas, and along with the thousands of H-4 dependents. These applications regularly file for extensions, changes of status, green cards, and other immigrant benefits. A simple missing document could now therefore become much more important. For example, immigration experts warn that an applicant could now accidentally leave you out of a text document, a certified translation, or even other piece of evidence needed to establish. Make no mistakes here, USCIS says that the responsibility is on the applicants to prove the case at the time of filing. The agency argues that the previous policy allowed incomplete or weak applications to slow down the processing, and in some cases, allowed the applications to file what it calls as a placeholder application just to obtain the related benefits. However, application lawyers say that the real application may be felt by the ordinary applicants who make genuine paperwork mistakes. And yet, there is another change that even matters. Even when the USCIS does not refer to REF, the response deadlines instead of routines giving applications the maximum 12 weeks. For certain reforms, including applications commonly used by the H-4 dependents and other changing immigration status, the maximum response period remains 30 days. So, what does that mean? It means that filing stage has become more important than ever before. Applicants cannot assume that they will always get a warning before their case is denied. Every supporting document, translation of a piece of evidence, and needs of the checked can be carefully submitted before the submission. This is not just a paperwork change, by the way. It is a signal that a tougher immigration approach is benefiting the process. When USCIS wants applicants to prove their eligibility, that from the very beginning, the policy is still new, and the immigration lawyers say that the full impact will become clearer as the office begins applying it across the different cases. For Indian applicants, students, the H-1B visa workers, the H-4 families, and the green card applicants, this message is simple. Do not rely on fix it later, because it is the new US immigration system that is getting the paperwork right, and the first time could make it the difference as soon as possible. Do not rely on fix it later strategy. Just keep your paperwork intact, keep the evidence intact, and the status intact with the legal eligibility authorized communities giving you reviews on your paperwork. How did you like this review? Make sure to comment down below.